everyone. It's really nice to be here, and I see a lot of familiar faces and friends who haven't sometimes seen each other for a long time. So this is a great opportunity. I should tell you that, as you may know, many years I ran or sat as a board member of CIRA, the Canadian Internet Registration Authority, for many years. And one of my lead priorities back when I was a CIRA board member was a community investment program, trying to find ways to ensure that CIRA would put money back into the community. And I chaired that committee while I was on the board, and I remember one of the very first applications we got was for this idea of a digital access day. We funded it, and to see it still running many years later, bringing the community together is just is amazing. So at least we made one right call. We made many right calls, but this is one that highlights that if you build it, they'll come, and I think it's great to see that take place. Now, the opportunity to come and speak, I think, comes at a particularly important moment. I think many of us will recognize that. We've got a political situation, of course, here in Canada, where we're likely to see a federal election in the coming months. We, sitting here in Ontario, find ourselves in the midst of an election right now. And the developments in the United States, President Trump, of course, are having just an enormous impact, seemingly on just about everything, and certainly on economic life and social life in Canada here as well. So I wanted to use these opening remarks to focus on three things. First, the effect from a digital perspective of prorogation. I suspect many of you will know some of the impacts, but just in case, I think it's worth highlighting just how notable the changes are, given that we've had prorogation. Talk a bit about the Trump effect, and there's a lot of different things one could talk about, but going to focus specifically on digital and cultural policies, and then offer a few thoughts about what comes next. And then I know that I'll have a chance to sit down with David Aiken for a little bit and talk a bit more about some of these issues. First, though, prorogation. And if you've been following the digital space and the various pieces of legislation that were at the House of Commons, you will know that there are any number of bills that are now effectively dead. Effectively, they are dead. And the prospect, given the likelihood of an election sometime in the next coming months, is that we are going to hit the reset button essentially on all of those different issues. So there's Bill C-27, the AI and privacy bill. The privacy side of that legislation under the Liberal government goes back quite a long time. Many of you will recall, and I can remember discussions in this forum, specifically around the digital charter when Navdeep Bains was the minister, which ultimately led to the first bill. It was Bill C-11, ironically enough as well. Bill C-11 took on a different meaning for many people in the internet space, but at the time that was the first Bill C-11. That died. That was followed by bringing that legislation back with, Bill C-27, which the government decided not just to keep the privacy elements of that legislation, but to add AI regulation at the same time, i.e. The privacy side, I think, certainly many thought, and I think rightly so, that there was room for improvement. An emphasis, for example, on privacy as a human right was one of the issues that got a lot of attention. But at the same time, there was, I think, a fair amount of consensus that Canada's privacy rules, PIPEDA, are now more than 25 years old. It was time for an update, and that the model gave a lot to work with and was fairly reasonable. At the same time, I think there was a lot of concern about the AI-related rules. It felt a little bit like you were given an assignment for the next day in school and didn't really have time to do your homework, so you just threw something quickly together and put it forward. And in the case of AI regulation, we chose to model this legislation, at least at first, largely on EU-style regulation. Prime Minister is literally in France right now, today, speaking largely about some of those same kinds of rules. And so we were trying to follow that as our model, initially without almost any detail whatsoever. It was essentially punting much of the detail. Later, when the Minister, François-Philippe Champagne, came to committee, suddenly there was a bit more meat on the bones, so to speak, a little bit more detail, but still many of the issues were left to regulation. And there was the sense that no one had really done the hard work of consulting and getting a sense of what exactly Canada wanted to do. What were our priorities when it comes to AI? Was it about the economy? Was it about creating some of these safeguards? Was it finding ways to reconcile both of those things? And so we ended up with this at committee, not a great process. It was very hard. I appeared, and I think a number of other people in the room have appeared before committee. We found that you had, of course, 5 minutes as is typical before a committee. You had to choose, were you talking about privacy, were you talking about AI? You might get the odd question, of course, but this was not really a way, I don't think, to study the bill in any meaningful way, and ultimately that legislation is going forward. Same is true for Bill C-63, the online harms legislation. That too had a windy path, let's say, to get to the point even of being legislation. It was really viewed, I believe, by government as part of a 3-part internet regulation package, the streaming bill, the news bill, and the online harms bill, and was always expected, I think, by the government to be the most controversial and most challenging of those bills. It's one of the reasons that it was delayed as long as it was. And in fact, when the government first put out a consultation on the issue, it was pretty roundly criticized by just about everyone, including those that would otherwise be expected to be supportive of that, which I think ultimately leads to the government doing a bit of a rethink. They created an advisory panel, they engaged in consultation, and came back, at least with respect to the responsibility of internet platforms, with something that was certainly not wholly unreasonable. It was this duty to act responsibly, and I think that that notion struck a chord with many as a way to sort of manage some of the challenges of balancing out freedom of expression concerns with recognizing that there are some real harms that exist online. One of the real problems, though, was that the government chose to include within this legislation amendments to the Criminal Code, amendments to the Canada Human Rights Act, which proved, I think quite rightly, far more controversial. It was clear from really day one that this was going to be the focal point for many, not the bulk of the legislation, which was really dealing with the online harms piece. And by the time Justice Minister Arif Virani offered up a compromise by saying he would split the bill, as many had been calling for almost literally from day one, it was simply far too late, and that legislation now too is down. One last piece, one last bill to note that, which has also died, it's really relevant to people in this room, is Bill C-26. It is a cybersecurity bill that includes significant telecom elements as well. It was at least in part a response to some of the issues around Huawei, but I think it certainly went far beyond that. And this is in some ways truth being stranger than fiction. There were certainly a lot of concerns about that legislation, but nevertheless, it made it through the House. It made it through on a substantive level through the Senate. But yet, towards the very end, someone came to the realization that there had been a drafting error in terms of renumbering the legislation based on some changes that would have had the effect of canceling the validity of a whole section of that legislation. So the Senate said they couldn't pass it in that form, sent it back to the House, where it sits until prorogation. And so the bill, notwithstanding the fact that it, from a substantive perspective, really did go through all of this, is now dead as well. So large amounts of what we spent the last couple of years talking about are now effectively dead, which really will raise some interesting questions and concerns about where to next. There's, I think, as well, of course, a significant element in terms of what Donald Trump is going to do and the kind of impact that is going to have, I think, in Canada. We've spent much of the last, or government spent much of the last couple of years talking about making web giants pay. I suspect when Donald Trump hears that, he hears make the United States pay. And it doesn't take much to recognize that that's not the sort of thing that sits particularly well with the current US administration. So if we take a look at bills that are now law, Bill C-11, for example, the Online Streaming Act, or Bill C-18, the Online News Act, both of which are strongly premised on the notion of requiring internet platforms. In the case of the streaming bill, that will, of course, include the Netflixes, Disneys, and Spotifys of the world. In the case of news, it's Google and Meta, although as everyone will know, Meta has chosen to comply with the legislation by stopping links to news on its platforms like Facebook and Instagram. But nevertheless, the whole notion is make these companies pay, put into different funds, or pay off to a collective that is designed to then redistribute some of that funding. Both of those bills or those laws are under some pressure. In the case of Bill C-11, the streaming bill, nothing has been paid yet. There are court challenges that are ongoing, and the court has stayed any requirement to pay until those challenges are sorted out. In the case of C-18, Well, Facebook's out, or Meta's out. Google has paid their initial $100 million, but that has yet to be distributed to anyone, although the expectation is that the first tranche of distributions may happen in the next month or so. Then there's the digital services tax, the DST, which is designed again to target larger companies based on revenues they generate from things like online platforms, from data, a range of other internet-related activities. We're talking in this instance about really big money. Pretty big money, I suppose, in the case of C11, but it's hundreds of millions in that context. It's billions in the context of the DST, the Parliamentary Budget Officer, estimating $7 billion of revenue over a 5-year period. It is designed to be retroactive. It goes back to 2022 in terms of payments. And while it has taken effect, there are no payments scheduled to be made until the summer. And so the question will be whether or not the U.S. pushes on the DST. Well, I don't think it's a question. The U.S. will continue to pressure on the DST. We may well seek to use that as a bargaining chip in terms of negotiation. We are hardly the only country that has DST. As I say, it is real money, but we're going to face, I think, some pretty significant pressure, perhaps using that, using that as a method to bargain against some of the other issues that we face. I think there's a whole cultural policy dimension here as well, which has a fair amount of overlap with some of the things that take place. You may have seen that President Trump just a week or two ago, right around the same time as we had our first battle with tariffs. I think it's only a week ago. Long. It's crazy. The timelines are kind of crazy. But in any event, Trump started focusing on access to the Canadian market for U.S. banks, incorrectly so in terms of what he was asserting. But how long before he starts talking about lack of access to the Canadian market for telecom companies or for broadcasters in terms of some of the protections that we have? How long before he raises the issue of simultaneous substitution, saying, why does Canada have a policy that allows Canadian broadcasters to replace the advertising from US broadcasters on the same programs and generate hundreds of millions of dollars in doing so? Arguing why shouldn't US broadcasters be the beneficiaries of all of that advertising, including instances when Canadians are accessing that feed? How long before he says, why is it that US companies are required to pay into various funds for CanCon, but are excluded from participating in those same funds because our CanCon system limits who can own the productions to Canadians, and so Netflix pays in but doesn't get to take out. I suspect it, frankly, won't be very long before those kinds of issues get raised, and Canada's response, potentially that this is how we've always done it, I don't think is going to prove particularly satisfying for you. So all of this raises the question of what comes next, and given that everything is moving so rapidly and there is so much uncertainty even as to who might lead on some of these issues, this is clearly just a guess, and we'll see how things get sorted out. One possibility, of course, is that, and we saw it play out briefly in terms of tariffs, that we will simply look to retaliate on any number of different issues. And so our approach might well be to say, if we are now in a trade war with the United States on some of these policies, and digital and cultural plays a significant role, we will look to identify ways in which we can retaliate in some fashion, trying to increase the amount of US domestic pressure in the hope of finding some sort of resolution on some of these issues. And we can probably identify a bunch of different issues in this regard. On my podcast this week, for example, Professor Richard Gold from McGill University comes on to talk about using patents as a potential tool that we could target. It is within Canadian law, and this is reflective similarly of international law, and it is used by the United States to suspend patents in certain circumstances. Might Canada say we are going to suspend upon request certain pharmaceutical patents? We've got a strong generic industry who might look at certain patents that are about to expire within the next couple of years and ask the government to suspend them early in order to begin to enter the market on a generic basis. That might well capture the attention of certainly US pharmaceutical companies and the US president. Might we similarly target AI patents, arguing that one of the ways to allow for our industry to better develop would be to suspend certain AI patents so that there would be, so to speak, a greater freedom to operate when it comes to some of these issues. Doesn't sound like the sort of thing that we would typically try to do, but these are different times to be sure. What about copyright? We extended the term of copyright under US pressure just a few years ago, included it within the USMCA, but we allowed for us, and we didn't take advantage of it, but we allowed Canada to require that extra 20 years to be subject to a registration requirement, saying that you would get, all copyright holders would get the same typical life of the author plus 50 years, and if they wanted the additional 20 years to make it life plus 70 as the standard is in the United States and in Europe, you'd have to simply request it through some easy registration process. Wouldn't create a significant hill for someone to have to climb, but nevertheless would make the default in terms of extension that something remains in the public domain as opposed to being still subject to protection. Now, the US has made term extension one of its major issues really around the world. And having a G7 country establish a registration requirement in compliance with international standards would be something that would also certainly capture the attention of any number of the larger players who might fear that it could be emulated by others. We could focus on data localization. I think, in fact, we can make a strong case that we should be focusing on data localization. This has also been a major issue for a long time for the United States. Many, of course, of the cloud servers are located in the US. They're anxious to ensure that data transfers easily across borders. We've seen any number of countries say that one of the best ways to protect your data is to ensure that it remains local, remains within the jurisdiction. Might we say that we have concerns, given some of the tensions between our countries, that we want to ensure that data remains local? How many Canadians have, if asked, if this continues to escalate, would be comfortable with their health data moving across the border and potentially being stored in the United States, or some of their financial data? Live in different times, and I think many who might have previously said they're not particularly concerned might increasingly have a different perspective. We could focus on de minimis, on the de minimis standard, which wouldn't be particularly popular with consumers, but would be pretty popular certainly with some US retailers. For many years, many of the larger US platforms, eBay and some others in particular, have focused on the customs de minimis standard for small packages, arguing that lots of consumers buy a lot of stuff in smaller amounts and that it makes sense to increase the standard, the threshold under which people can freely import without any customs duties or taxes being applied. We did, a number of years ago, raise that standard. Leaving it's up to $800 for travelers after 48 hours, but the standards are different in terms of smaller packages. Canada might well say, well, why should we be facilitating that cross-border commerce from the United States with consumers purchasing from US players in an environment where people are focused on buy Canadian? One of the ways that you incentivize buying Canadian is to actually make it more expensive to buy from elsewhere. And the de minimis standard might be one way to do that. So there are a number of kinds of things that we could focus on in terms of seeking to respond, to say that from a digital perspective, in terms of what we might be able to do. We might also consider shifting away from the US orbit. I mean, we're already seeing much talk about that, certainly from a trade-related perspective, but we might think about that from a regulatory perspective as well. As I mentioned, Prime Minister in Europe right now talking about AI. Might Canada move with a number of other countries to say that this is where our focus is, this is the kind of regulation that we want, whether it be on data or on AI or on any number of different kinds of issues, and certainly competition rules being an example of another, where the EU, through its Digital Markets Act, and from a consumer perspective, which is with its Digital Services Act, far more aggressive about regulating. Canada has been a bit more reticent about doing so, although we've seen the Competition Bureau more recently take action against Google. Might Canada say that this is where we're placing our bet in this current environment, and we seek to have our rules look much more like European rules or some of the global rules, and enforcement actions to match? There's, of course, another possibility, though. We might simply try to use some of these issues as bargaining chips, saying that DSP would be nice and cross-industry subsidies when it comes to something like C11 is pretty good, but ensuring that our steel and aluminum and dairy and some of the other products that we sell actively into the United States goes in tariff-free might be more important economically, and so we're prepared to sacrifice some of the gains and benefits that we have accrued on some of those kinds of issues in return for a lessening on some of those tariffs. So it might simply just be an instance where we seek to negotiate on some of these issues. We might also recognize that there are costs to having taken a very adversarial relationship with some of the big tech companies. Just before Chrysler Freeland sort of blew up the government, so to speak, I had a meeting with senior officials within the government who were focused on disinformation within the context of the forthcoming election. It's going to happen at some point in time. And they were quite candid in saying, these were not officials from Heritage, as will be clear in just a sec. They were quite clear in saying, and candid in saying, that they were looking to try to foster a direct relationship with some of the large platforms in dealing with misinformation during an election campaign, but that relationship had been badly damaged by Heritage, frankly, the exact words that they had. And so their ability to actively work with the very companies that were in the best position to try to deal with this had been undermined through the last couple of years of policies where we were happier having a more adversarial relationship with these companies. Might Canada say that, you know what, some of these issues are also really important. We need to find a way to work with some of these large tech companies as opposed to simply looking at them, as I've sometimes said, as policy ATMs, where we get various withdrawals to fund some of our initiatives. And finally, I think that one of the things that we are going to have to come to grips with is that there are trade-offs in all of these policies, and we have to do a far better job of recognizing what those trade-offs are, and frankly have a far more honest conversation about some of the costs of regulating or not regulating and what some of the implications are. I'd use AI as, I think, a perfect example of that. As I mentioned just this week, we're effectively doubling down on the regulatory model, it would seem, with a lot of emphasis on sort of the EU AI Act and categorizing AI systems based on their risk at one end of the spectrum, minimal or medium level risk, which may involve some very basic notions of regulation, but nothing particularly significant. At the other end of the spectrum, potentially banning certain AI systems or categorizing them as high risk and establishing a very significant regulatory framework associated with all of them. Now that's the approach we're seeing in the EU and the so-called Brussels effect, the notion that the EU is first to market with regulations in the hope that others will follow that model, is a playbook that we've seen before. We see it in privacy. We're now seeing it play out again with respect to AI. But we live in an environment where AI is not just about protection, one would think, or one would hope, but there's also obviously enormous economic consequences to the kinds of choices we make with respect to AI. And in the United States, literally on the first day or on the second day, Donald Trump whisked away the Biden administration's executive order on AI. It didn't include some of the same kinds of heavier regulations that you've seen in the EU, but it certainly was suggestive of a more pro-regulatory approach. It seems pretty apparent that the United States will look at AI, at least under this administration, not through the lens of how do you protect, but how do you lead from an economic perspective. And I would suggest that the arrival of DeepSeek from China just over the last few weeks, in terms of at least public consciousness, will only exacerbate the perspective that this is a global war for leadership on AI, that the economic consequences of who wins that battle are enormous, and the US will take the position that we will do whatever is necessary to be a leader, even if that means deregulating at a fast clip to pave the way for investment and leadership in the space. Well, what choice do we make? We have on the one hand a model that says the way to go here is with significant amount of regulations. At the same time, we live right beside a country that is saying we want to be a leader, and if that means we take your AI companies and we take your potential AI investment, no amount of government announcements about funding for data centers and other AI support is going to change the flow of that money and that talent going south of the border. Now, I'm not sure what the right choice is. I think there are real concerns around AI, and I think we've got to find ways to reconcile some of those concerns with the economic risks that we face if we find ourselves on the outside looking in. I think it's essential to recognize that on that issue, as well as on many others, it's the kind of policy conversation that we simply have not had. Those that dared to criticize some of the legislation in the past were treated as stooges of big tech and roundly dismissed by the government. And so we found ourselves in an environment where the ability to actually engage in a real conversation about some of these policy trade-offs and decide for ourselves what is best for Canada has often been missing. At this particular moment and in this community focused on these kinds of issues, I hope that now's the time to start having that kind of conversation. Thanks so much for your attention.